So what we'll do next is that there's a book, as we've been telling you, that's mostly student-led. And before you, we have a number of people. We have editors of the book. So we have Professor John Osogo-Ambani, the Dean of the Law School. We have the Editor-in-Chief of the Kabarak Law Review, fourth-year student. His name is, let me just, for some reason it has disappeared on me right now. He's my good friend, Elvis Mogesa. I apologize, Elvis. People might think we don't know each other. And of course, there is the managing editor of the Kabarak University Press and a tutorial fellow at Kabarak Law School, Melissa Mongai. Both of them are at Kabarak. Also, we have the HOD, Cedric Kadima, with us on stage. He's a contributor in the book, and another contributor, a fourth-year student, Kenaya Komba, and managing editor of our arbitration blog. Remind me the name? Sawia blog, which is our blog dedicated to multiple justice systems, with a focus on arbitration and mediation. She's also a contributor to this book. The session will be led by Evans Ogada, who is a Kenyan constitutional and administrative law litigator, academic and legal consultant, an advocate of the High Court, with an LLB and an LLM in public international law from the University of Nairobi. He has a diploma in French and culture from Alliance Française. He has represented parties in landmark cases, including the BBI case, Third Way Alliance and the Kuro Court versus the AG, which is the Haiti police deployment case, the Finance Act 2023 case, the judges appointment case, Adrian Kimotho Njenga versus AG, to compel President Uhuru to appoint judges after their after the recommendation of the JSC without any amendments. Martha Karua versus AG at the East African Court of Justice, the minimum tax case, amongst others. He has argued before the African Court on Human and People's Rights. He served with the KATIBA Institute, chairperson of the East African Law Society's Rule of Law Committee, sits on several LSK committees, including the Public Interest and Constitutional Judicial Review Bar and Bench Committee. He's a member of ICJ Kenya, African Judiciary's Research Network, International Law, Human Rights Jurisprudence, Property Law, and Torts teacher, and at the University of Nairobi as an adjunct lecturer, and is widely published on constitutional law, bail and bond jurisprudence, public participation, and judicial independence. He has presented his papers both locally and internationally, and conducted training for judges, state councils, political parties, civil society on the topics of international law and constitutional law. I cannot read any more of his accolades without us having to come back tomorrow. So please give a round of applause to our facilitator, Evans Ogada, who will take it away.
Actually, you can give me the mic. I'll start. Yes, thank you very much. We have been introduced. The way we have agreed, Doctor of Ceremony, is that we shall work together so that he is not an outsider to the editors of the book. We shall contribute to knowledge together. So I assumed powers at some point so that we move together. Our practice at the law school is when we have a program like this, we make it a military operation and assign it a code name. So this one, I think I can announce now since it's done, was codenamed Operation by Location, because we're going to be in 2 locations at the same time. Oh, my coffee. So the operation means that there will be the other editors are in Kabarak and the others are here. The 3 are here, then the 2 are the other side. Then the more than 40 authors, some here and others in Kabarak as well. And we are here to stand for all of them. We're going to be very brief. We'll take a very short time to talk and then open up for plenary. Because I think you might be scared that we're going to talk about the 40 articles of KATIBA. That's impossible to do. But what we've rather agreed is that I will give a very brief overall framework that then will guide us to ask some questions. And then when we answer those questions, we'll believe that we have done justice in the circumstances of the day. Like I said, we are looking at the Bill of Rights backwards all the way to now. And that's a good place to start, because when you look at the challenge Professor Ambrina Manch has given us, is to go beyond law and the provision as it stands, give it life backwards and forward. Think through the problem historically and then forward. And I think that is really the tempo of this particular platform. So when we look at the Bill of Rights in the repealed order, I think that's where we'll start, then see how things have changed the new one, but in a very, like I said, easy way. We're also conscious of the fact that there are members who are not lawyers, many more, especially in Kabarak University at the moment, and we will be a bit minimized in terms of legalese to make our communication possible. So I go back. When you think about the problems of the Bill of Rights, and I've reflected upon them for some time now, and I can put them under very 4 broad categories. Number 1 is the scope of rights. Number 2, the equality and discrimination clause. Number 3, the institutional framework for protection. And then number 4, the problem of limitations and derogation. I believe that if we do some justice to those ones, we will have at least begun the conversation on a big day like this. On the first one, the problem we had before, and I was among those who would complain about the repealed constitution, was that it was too limited, it was too brief. In fact, coming at the time of the Cold War, I believe, especially after the Second World War, our Bill of Rights appeared to have taken a very narrow interest in human rights and only secured civil and political rights. And even in those, it wasn't elaborate enough. So a lot of us in civil society at that time were agitating for an expanded scope of protection. And that we got. When you take your time to look at the Bill of Rights now, you will see a very, very detailed catalog of entitlements there. There are new rights, including for youth, older persons. You will see rights, such things that we never even thought would have in Kenya, like access to information, privacy, and I believe that that should mean something to us. So I'll be coming to this panel to ask them whether it has actually done that, because we've scored big there. The second problem was, and I was among those who complained, and many academics did and civil society actors, that the Bill of Rights had a very limited equality and non-discrimination provisions. For example, if you look at the equivalent of our Article 27, is it 4.3 right now, it only secured very few groups. In fact, I counted, just 9. You know, the one that says no one shall be discriminated upon on these grounds, 1, 2, 3, 4, sex, color, creed. It actually just protected 9. I have counted the new constitutional order, we protect as many as 17. So which means we have more than doubled, or around doubled the provision or the protection. The other thing we lamented was always the fact that the constitution did not go as far as deal with substantive justice. You know, we have formal equality, but also substantive equality. That in addition to just saying we're equal, there needs to be other measures, for example, affirmative action, to bring on board those that have been left behind historically. The old constitution didn't do that, but if you check the new one, Article 27, I think Part 6, you will see very, very detailed provisions on affirmative action, not just for women, but also for persons with disability, also for other minority and marginalized groups. I'll be coming back to this panel to ask them whether that has meant something. Okay. The other thing was the institutions. We kept complaining that the institutions to protect human rights were far incapacitated. In fact, the main mechanism of protecting human rights those days was the judiciary. Okay? And the judiciary itself was mired in a lot of confusion. For example, judges themselves appeared reluctant to enforce human rights. They appeared to emphasize limitations rather than to promote the rights. And then they just invented all manner of technicalities of procedures. If it was a human rights class, I would refer to several, tens and tens of cases. But I think you know them. One case, quite big, just around here, Uhuru Park, you are told that unless you're affected directly, you can't come to court. I think that's the Wangari Maathai case, isn't it? You must have, you are self-affected. If you are not, then shut up. And the questions we would ask is, then who will speak for the environment? The environment will never speak for itself. Judges would tell you that you can't even represent someone who can't represent themselves. They will tell you that you have to know the provision you are complaining about. If you can't point at it, then you have no space. I think we've had, for the lawyers, you know the cases I'm referring to. The most ridiculous for me, and I've always mentioned to my students, is the situation where the Chief Justice had not written rules to enforce the Bill of Rights. And you would go to court and they tell you the Chief Justice has not made rules, which was okay. But I think the ridiculous day for me was when the Chief Justice himself was seated and announced that he had not made rules, and therefore the Bill of Rights was not operative. I think that's so ridiculous. So we were at that level in terms of institutional protection. What we've done in the new constitution is actually to deal with all those things. If you look at Article 22, for example, for the lawyers, let's be easy on the others, you will actually see that we've remedied each of those things I've talked about, the technicalities of procedure, suing on behalf of another, public interest litigation, and all that, standing, and all those kind of complexities that were being imposed upon us before. In addition, you will notice that we have added a national human rights body, the Kenya National Commission on Human Rights, which the constitution writers allowed Parliament to break down into parts, which it has done. So we have one commission on gender, the other one on human rights generally, the other one on maladministration, the ombudsperson. And the idea is to expand the institutional framework for protecting human rights. Again, I'm coming to this group just shortly to ask them whether this expanded institutional framework has led to something good for us. Are we much better off 15 years later in a new setup of expanded rights? Then the last problem that we had with that constitution was limitations and derogations. And that began with the constitution itself. I don't know, it's very ridiculous. If you're looking at the old Bill of Rights, if you can find it, the repealed constitution, look at, I think it's Article 72, yeah, I think I wrote it, 72.1 is one of the most interesting provisions I used to teach and laugh at, where the constitution provides a right in 2 lines, then takes several lines, taking the right away. In fact, it gives 10 provisions, 1, 2, 3, up to 10, taking away what it provided in 2 lines, actually 1.5 lines. And so we began to talk about a bill of clawbacks rather than a bill of rights, because it emphasized more on the clawbacks than the rights it actually gave. You know, that was a major problem of that Bill of Rights. Then emergencies was so loosely held. The executive could always put us in state of emergencies and therefore limit or even derogate from our rights. When you look keenly at, and I want to just refer to us for our own checking for the non-lawyers, Article 24 and 58, you will see that a lot of thinking has gone into limitations and also derogation. We're dealing with a situation now where to limit a right, if we were to follow the Constitution, you really have to show that you have good reasons to do that, reasons that can stand in any open and democratic society based on human rights, human dignity, and so forth. To derogate from human rights, you really have to show very serious reasons to do that, and it can't be for long, very short time, and the institutional frameworks ensure that mandate is renewed through the representatives of the people, and in any case, we can always go to the Supreme Court to contest that derogation. So there's actually proper framework for that. And again, I'm coming to this platform to ask them questions, what they think we have achieved from that. And then we can move forward. Those are the 4 main areas I thought about as problems with the Bill of Rights, and that can help us summarize the conversation. So we can come to the beginning. I'd mentioned Mr. KATIBA. I think you noticed that we now have an expanded scope of Bill of Rights. And one of the things we have there now is privacy, access to information. You can pick one or eight, do you think these things have helped us? Are we better off?
Thank you, Professor. I think because of our audience and also those following us elsewhere, I'll speak in English, and where my English fails, because the 3 of us, I think we speak French, I'll just switch to French. But yes, there's an expanded scope in the Bill of Rights, especially when we promulgated it in 2010. For instance, when you look at the right to privacy, the right to access to information, we didn't have that textual guarantee in the 1963 Constitution, which was later dismembered quite a number of times. But in the 2010 Constitution, we have a textual guarantee. But again, I would want to just borrow the inference that Professor Manji gave on conflicted promises. In the 2010 Constitution, we have an expanded scope that guarantees a textual right. When you read it, you have it in the Constitution. You have a physical copy, and you can read that you have the right to privacy. You have the right to access to information. But when it comes to the actual implementation, the Constitution has given us a conflicted promise, especially by the persons who are supposed to implement that right, which is the state. You would find in many cases where the state or a public body actually frustrates a citizen when it comes to access to information. So I would say that aside from the textual guarantee, we need to do more on implementation, which is at our worst, I think.
Have you tried to access information?
Yes. My colleague who is not here, some time back, I think in 2020, we wrote to a government institution, a statutory body. I think that maybe I should just disclose, the Kenya School of Law.
Yes. There are many candidates here. I've seen them, so they can relate.
Yeah, where we sought to seek some information regarding the distribution of fees. Remember, the institution had charged fees for physical classes, but at some point, somewhere, the institution switched to virtual, but did not give guarantees on revising the fees or how, because I would imagine hosting an online program will be less or it will be cheaper. But I think it's now 5 years later, we're told Parliament is still auditing the accounts and they would send what they receive. So I don't know if...
We don't have the answer yet.
We don't have the answer yet.
Thank you. Thank you very much. Mr. Ogada, have you asked for information before?
Oh yes, I'm very proactive in that space. And I can say that we check a mixed bag in terms of access to information. So for example, we... in Wanjiro Gikonyo and TISA versus CS Finance, I think this is reported, we sought information from the Ministry of Finance for the loans and agreements that had been entered into on behalf of Kenya for a period of 9 years. Remember, people have been signing loans out there, money borrowed on behalf of the Republic, and the citizens know nothing. We sought in that information, and luckily for us, the Commission on Administrative Justice, the CAJ, the Ombudsperson's Office, was proactive enough to direct the ministry to provide the information, which they did not, and we went to court. I can assure you that the court saw things our way, and we have a court order to date that I am told is called FCPA, John Mbadi is yet to honor, because he was ordered as a ministry to disclose all agreements and to also account for the money borrowed. And the beauty about that case is this: it inadvertently reversed or tinkered with an order of the Supreme Court, where the Supreme Court had refused to compel disclosure in terms of agreements around the SGR. So you see the High Court making a positive order, but the Supreme Court up there, and so many of us have a problem with that finality or pronouncement by the Supreme Court on a number of issues, because the Supreme Court has been and is a concern for us on a number of questions. Now, in terms of the administrative component, I can say for a fact that the Commission on Administrative Justice has been doing a commendably good job. The Ombudsman currently is quite proactive. If you write to him, copying him when you seek information, he's quite proactive in terms of helping citizens to get the information. So niliona muungano wa wanavijiji hapa, community groups, watu wa Nairobi. Vipi, mko salama? Mimi nilizaliwa Nairobi, so I'll switch to Sheng. Mukiwa na maswali ya access to information, unataka story yote from Gava, na Gava imenyamazia, tafuteni Ombudsman. Ombudsman yuko kwa ofisi West End Building, Westlands. Ukifika hapo utauliza, watakushow pali unaweza enda huko hivyo uambie I saw this information from Makarao or whichever office ya Gava, including State House. Taka information watupatie wakatukazia. So mkienda pale mkashow huo Ombudsman atawasaidia. Sasa fite.
We check a mixed bag. I think that's what is coming out there. So let me try the other issue that we discussed. And this one, I think I will go to Kabarak. Ms. Mungai is there, and Elvis Mogesa, the other co-editors. Ms. Mungai, I've just mentioned that we have expanded the scope of equality provisions, and even including substantive equality now. Do you think the women are doing much better, for example? If you can allow the people in Kabarak to speak. Can you hear us? And can you speak, the people in Kabarak? If they're taking time, maybe I can move to another limp that can be addressed here. And I think, Mr. Ogada, you'd already begun the discussion. I mentioned earlier that the institutional framework for human rights protection has been expanded in the new constitutional order. You have already mentioned that, for example, the Commission on Administrative Justice, which was not there before, is already doing something, at least in the area of access to information, where actually the mandate resides. Do you think that for you as well, the story is one of success, where the increase of institutional framework then has led to much more human rights realization?
Thank you, Prof. Can I speak in French so that Cedric will translate for you?
Okay, can speak in Lingala. But our student is from Congo, so she can speak French, Lingala, and which one?
And good Swahili.
Bad Swahili, Goma. Thank you.
So what has been achieved? From where I stand, I think the Constitution has really tried. For example, it created this independent judiciary. Institutions not only like the Kenyan National Human Rights Commission, but also IPOA and the EACC and so many others have been created to help investigate policy abuses, corruption, human rights violation, and the court has challenged unconstitutional laws at some point, some of them. And some few examples here can be, for example, the Gen Z's protest about the financial bill. We can also see the decision on the Meatbell case, as our very own Faith Odhiambo has mentioned. And but still, even though we have tried to establish all these institutions and saying that we have a judiciary, we still have problems of maybe costs and access to this justice or the institutions. There is a case that the coalition on violence against women and others versus the AG and others. This is on the delay of justice. This is a case that I think started, and these victims are from the 207 atrocities, women who have been raped and all these things, but only managed to get justice in this year, if not last year, and only half of them managed. So can you imagine from 207, and there is others who are continuing fighting these injustices. So yes, Prof, I think we have tried, but still there is a lot to talk about.
I see. So still the issue of delay, the courts can do something, but the delay issue is still there. Ogada, in 1 minute, do you have any comment on that? Since
can
you're
you
here.
hear us now?
Yes, we can, Ms. Mungai. I'm coming back to you. Let me just hear from Ogada in a minute. She's talking about the fact that we have made some progress. Yes, Ms. Mungai, you can hear you.
Ogada.
I'm coming to you. Yes.
Certainly, there are delays in terms of access to information. There are administrative bottlenecks, the cost implications.
In terms of the judiciary?
In terms of the judiciary, it depends with what court station or which judicial officer you are before. A good number of them are trying. Constitutional cases are moving. The challenge I know with the station in Nairobi, for example, is that they are short-staffed. So that impacts on a couple of questions.
So, again, checkered.
Yes, checkered.
Thank you.
Yes.
Now I go back to Kabarak, since now they can hear us. Ms. Mungai had asked the question about equality and non-discrimination.
We could all along, Prof.
Did you hear it?
Yes, I had the question on equality.
Yes.
Yes, and before I get into that, we are just so grateful to be bilocating, so we are happy the operation is ongoing. But before I get to the equality question, on the expanded scope of human rights, I think Mogesa and I also wanted to chime in a little bit, but very briefly, there was a discussion during the 3-day conference here, at least the 2-day, and a lady from the community, I'm trying to see if she's here, Joyce, she's not there, but she has a very nice philosophical question on what does it take to have a right in the Bill of Rights? What process, how long? So the people are still asking, yes, it's expanded, but what does it take to get more in there? What does it take to have that one in the Bill of Rights while another one is not as explicit? So I thought that was interesting. Briefly on the equality question, again from the community I learned, yes, well, there's that expounded grounds for non-discrimination. People are still being asked, are you physically disabled enough? Are you woman enough to be in politics? I had a representative from CRU in her opening remarks speak about the 2/3 gender rule litigation, but also because a fan, scholarly fan of Professor Mbrina Manji, I'll just echo what she said there because I think it rings true, that every time we speak about equality, kila wakati tunaongea mambo ya usawa, ya utu, and then uongozi inaingilia hapo, it becomes mambo ya siasa, sindio? They turn it technical to other matters of governance. So I think we still need to check on that, matters of social assistance, matters of political party representation of women and how they fund them in their campaigns, and so on and so forth. Let me move it to Mogesa while you still have us to at least say something brief, then we go back to you guys at Saruba.
Thank you so much. I believe you can still hear some. I'm excited once again to be in this wonderful panel. And as we are discussing these four larger themes, perhaps I'd stick to the one on limitation and derogations, Prof. So while you've mentioned that, yes, Article 24 and Article 48 are sort of remedying relics of clawback clauses, right? That we had so many provisions that are taking away the rights, and now we have this one Article 24 that gives sort of a standard. And at least from the conference, something that came up is the method in which at least the courts are trying to understand the limitation and derogation. So an interesting example would be this recent 2025 judgment, the end of June. The Supreme Court ruled against this matter on Muslim inheritance of children out of wedlock, right? The Fatuma Athman Abu Afaraj case. So you see them using the proportionality test, right? A transplanted test, but then in the same time, they call Islam law repugnant, using a colonial yardstick. So what this says really, and what the chapter, the book will interrogate, is the method in enforcing this limitation clauses, right? Are we doing it right? Are we transplanting both colonial yardsticks and even laws that are sort of not truly limiting the rights as we had envisioned in Article 24? So perhaps, that's just something that I'm hoping this commentary will question the method, right, in how we are realizing these rights. Thank you. Back to you, Prof.
Okay. Thank you very much, the people in Mashinani. Now that you made a joke of us. Ms. Mungai, if I may ask you to just say something about women. I know you are a feminist. It's not an insult. It's something. I am one as well. In one minute, do you think the women in Kenya are better off than they were on 26th August 2010? 26th August 2010. Are the women in Kenya much better? Because a day after that, we had a new constitutional order. That would be your closing shot. Then I come to Mogesa's closing shot, and then all of us here make a 1 minute closing shot, and we finish.
Feminism, I correct to, is living. So, meaning it has so many aspects to it. It's not just the legal front of feminism or the political front, but also the social and historical ones. In a nutshell, it's called decolonial feminism. So it keeps going back and forth. And if I can just comment on maybe the conversations I've seen with regard to Article 27 or matters of affirmative action, as a decolonial feminist, I still see that we are centering on difference too much. We are centering on not the bigger picture. It's not contextual. So even in these discussions, I had conversations about what a man can do, women do, 50 times better. But yet, if we can just concentrate on what was womanhood a representation of from the past as we move to the present, and what can we learn from that and encourage it. We had a text here, I think you'll receive it, the people in Sarova, on harvesting equality, and it was saying woman is the custodian of life, she's the seed. And that means many things because she works in variety of ways. You know, her livelihood is diversity. So we don't have to shape her into one particular thing. So if we can continue thinking about diversity and coalitions, which I am always a fan of. I love what CREW does there with sexual reproductive health rights because it deals with life, it deals with matters maternity, it deals with matters consciousness and wisdom. So those kind of conversations need to keep going, even for young girls who we tend to leave behind. So I think when those conversations are driven by that framework of unity and less differences, I think we're better off. And then lastly, just to say, on Article 58, as my parting shot, just to pick up from Ogesa, that, and it's connected with wisdom, he talked about the method. We are going to see more about this method of limitations. I think my last parting shot there is also to see when the leadership will be triggered to make conscious decisions about its people, even in times of disasters, in times of disease, in times of poverty, because the people have been asking them to declare an emergency on femicide, declare an emergency on poor education systems, declare an emergency on what Vema was saying, corruption and poor governance. We were singing here on stage. Thank you very much, Vema, for that intellectual interlude. So that will be my parting shot. I cannot wait to see the wisdom that may be oozing out of our governance systems in terms of Bill of Rights.
Thank you.
Thank you.
Mogesa, your parting shot?
Yes, for
and
me,
as you do that, Mogesa, I would like to hear your call. Your call, are we better off 15 years later?
Prof, President Faith likened the Constitution, to a teenager, right? At 14 or at 15, where you close to your parents. So that's how I see the Constitution in its teenage years, right? So the trend that we're seeing is a polarity of regression and progression. So as also similar to teenagers, right? There are good days and bad days. So at least for me, it's sort of my positionality as a young scholar, right? Someone who wants to ensure that we keep the fidelity of the Constitution, it's just to use it in its teenage years as it goes on to its 20s, right? To ensure that we stick to the fidelity. We understand, we trigger as Prof. Manji mentioned in the morning, like it started a conversation. So we further that conversation in the temporalities of it. Yes, Prof. Thank you so much.
Thank you very much. Can I, Komba? Your parting shot? And if you can make a call, and since you're an international student, I think you have an outside eye looking at us. I think you can make a more sober judgment.
Just as I said on Monday, I think, Prof, from where I sit, I think and I believe the Kenyan Constitution is one of the most progressive in Africa. And your Bill of Rights is just one of the most, one of the most exhaustive list of human rights. And even that is even compared to ours. And I used to tell my colleagues, like, I wish back home we had the same energy to create Gen Z's movement, to fight for our rights, or even just to do half of what you guys are doing for the country. So I really think, and you are doing great, and yeah, we have to clap for ourselves for that. But then also maybe just my 1 minute I can take up from women and what Melissa was saying, Prof. If you also. I think we focus too much on getting also one of the community members last on Monday asked me a question about, well, we only blaming the state about all these things that happened, but what about us? So we don't do anything. He was talking on a perspective that a Kenyan is also doing bad to another Kenyans, but we only focus on the state. And I was in a hurry to tell him, no, the state is supposed to protect us. So these other things, we'll talk about it, but not here. First of all, the state has to protect us, so we have to blame them for all these things. But then also, I sat down and I was like, we also have cases of democracy. We are fighting for this right. We are fighting for this leadership position. But as women, once we get to this position, what are we doing for other women, or what are we doing to change this thing? And I hope my boss will allow me to use his example of one day he was going at the bank and he saw all women running to the man queue so that that guy can let them get in quickly. And all men are following the women, but you will never see a woman going to the woman queue because we have been brought up in a patriarchal ideologies. So we are also growing in a mentality that we also have to oppress fellow women, because we have seen all our life men oppressing women. So maybe I will leave it to you, and I would also like to hear what you have to say about it. Thank you, Prof.
Thank you. Yes, you can clap for her. Thank you. I agree with you that we have a very progressive Bill of Rights. But if you'll remember what, I believe by your boss you meant Eric Mukoya. Yes. Yes, him. Thank you. If you heard what he said earlier, is that if we think we're ahead of Tanzania and Uganda, they're operating a very old constitution. In fact, for Tanzania, it's nearly the independence one. So perhaps you're doing well in Congo, fairly well with your constitution than ours, but that's a discussion for another day. So thank you very much, Kenaya, for helping us understand our country. Mr. Kadima, sideways, backwards, forward, where are we with the Bill of Rights 15 years later?
Since it has been equated to being a teenager, I don't know if we are raising an irresponsible teenager or just a teenager who is stubborn and will get to be responsible quite or much later in life. But we don't know now when. I'm particularly interested in the right to assemble, demonstrate, and picket, which I think my colleague Tuku is there, very interested in such a right. And also I can see Gloria, who is always at the forefront when it comes to assemblies, demonstrations, and picketing. I have seen examples whereby the state is no respecter at all. And this has been throughout the years. I think one of the rights that has been treated consistently with deficiency is the right to assemble, demonstrate, and picket. Since the colonial times to the immediate after colonial governments, and also to the third wave, which is now the most recent governments, or we can say the last 3 administrations. Then I think we should ask ourselves why, for example, rights such as the right to assembly, demonstration, and picketing have been treated with the same restriction for the last 70, 80, or close to 100 years. I think there is a problem in that. And I think I diagnosed the problem to believe that the state always thinks that when normal mwananchi, when a mwananchi participates directly into matters of governance, they always put a question that the mwananchi is trying to overthrow the government, or is challenging the government, or is threatening the security of the government. And I think we need to impeach that mentality from the state and install a mentality that when citizens, for example, participate directly in their governance, it is their inherent right and not a challenge to the government that they themselves elected and formed. So I think we need to raise a more responsible teenager in terms of the custodians who are charged with implementing the Constitution. There, I believe we still have a lot of problem to fix, because how else can we explain that that right has been treated with restriction for the last 80, 100 years? So my call is, we need to change the mentality, both of the citizens and also of the state, for us to be able to enjoy the rights in our Constitution effectively.
Thank you. Ogada, if I give you 3 minutes to summarize us and make your call, because we are really doing badly on time, that would be good.
Yes, sir.
Thank you.
So before niingie hii kilami kizungu, watu wangu tuchukue kura. Sasa tuchukue kura, tuweke eyes on the prize, ensure that much as tunateta social media, tunateta mtaani, tuko na kura, tukiitwa kupiga kura, tuende tupige kura vile inapaswa. Sasa mkiletewa ngori na makarao, all that, tuko hapa LSK, muliona Faith hapa asubuhi, yeah? Kuna Gloria iko huko nyuma, huyo ni one of the leaders LSK. Under these people, we have been able to sort a number of issues. So endeleeni na activism, do it in a respectful manner, as usual, tutetee katiba. Ama vipi? Now, we are in a period of democratic and constitutional backsliding, and we face a myriad of challenges. I'm particularly concerned with what we are seeing with the judiciary. The first two cohorts of the Constitutional Court, particularly in Nairobi, offered some ray of hope. We had hoped to see consistency in terms of the products we saw from the court. Unfortunately, today we are seeing a regression. Students of Kabarak, my good friends, we are seeing Anrita come back to court. Anrita is a product of old orthodoxy. Those are not the kind of lawyers, at least I know, Professor Mbani is teaching you to be. We are being taught to be more innovative and think of the substance, not the procedure. So, where do we go, and what caution do I give us? I want to send you back to history, and in summary, in conclusion, I'm glad Professor Dr. Rothenberger is here. She will confirm whether I'm lying or not. We go back to Germany. Germany 1918 to about 1933. Germany has a very good constitution. Liberal. It brings in the principle called Länder. Devolution, what we have here. And the Germans believe a lot. It's a very strong belief in their psychic, the Länder. They have just about what we have in our constitution. And there's this politician called Philip Schiedmann. He was a social democrat. He was very excited. We are getting rid of the monarchy. We are bringing in a new order. And what does Philip Schiedmann do on 9th of November 1918? He goes to the Riksdag, the window of the Riksdag, the German parliament, and he shouts, "The old and rotten, the monarchy has collapsed. Long live the new republic. Long live the German Republic." He was ecstatic. That's the mood we were in 2010. Sindio? Yote yawezekana? And we agree that we are going to have a new constitution. Today, citizens are being abducted. People are being killed. We have decisions from the court that give us cause for alarm. We have to remain vigilant. We have to ask our questions and do so boldly and consistently. Thank you.
Very much. Thank you very much, Bwana Ogada. Then I'll also take my 1 minute, and then we'll be handing over the mic to the Doctor of Ceremony. Unless you want to ask a question, which I don't think we have time. One. He says we can ask one. Not now. Oh, I finished? Then we ask a question. Okay. For the last 2 days, like I said, in Kabarak, but before that, a number of webinars, about 4 webinars, we have been reflecting on KATIBA. And this is the sad part. I have tried to ask each of the, authors of the 40 chapters of the book that we are launching today to tell me whether they can make a call. Have we gone forward? Have we gone backwards? None of them is able to say we are going forward. What they are saying, however, is that there are some steps backwards, some steps forward, some steps sideways, and so we are like a vehicle stuck in mud. You notice that all members of this panel could not answer that question either. They just kept saying, we are there, back, made progress there and not the other, and eventually avoiding it altogether. And that's because what we are finding in our research is the same as what they are saying. They're actually reflecting exactly what they find. The word to use for this is that we are having an incomplete constitutional transformation. It's incomplete. Where you think we have made it on this aspect, on the other one, we are behind. Where you think we have made 3 steps forward on the other, we make 4 backwards on the other, 2 sideways on the other. And so we can speak of an incomplete transformation of our constitution. What then is my challenge if that is the case? That we must start identifying areas where we are struggling and subjecting them to the oven so that they are also completed in terms of transformation. That would be my call to all of us today. The book, which we'll launch later, we'll be able to put it online later for everyone to find it when it's ready. We'll do an online version for you because we can't produce for everyone and we can't reach everyone in terms of distribution. Please look at it, because one of the things we have told ourselves to do is to be able to identify those areas that are incomplete together with those ones that are complete, and then recommend things that we can do differently going forward. Welcome, and thank you very much. Thank you.
I've been requested to give one question from a member of the CBO. I don't know, cameraman, if you can follow.
Sawa. Wazalendo tupo? Sawa. Naogopa kutumia comrade kwa sababu mara mingi siku hizi tuna misuse hiyo comrade pia. Unaona? Sasa wazalendo na sound poa, na hiyo wazalendo ndio tulianzaga nayo hapa Freedom Corner hapa hivi. Sasa mimi jambo langu kwanza napenda kusema mimi nashukuru sana chairperson ama president wa LSK. Mazee ameamsha wa Kenya na ameamsha Bill of Right kwa hii country. Ilikuwa imeenda chini. Na naona kuna kazi, wamama wanafanya kazi. Na mimi namshukuru sana. Hebu tumpigie makofi. Alikuwa hapa, mkimwona tu mwambie sisi kama community tuna appreciate kazi ile anafanya, na amefanya government wanachangamka kila mara. Design wakienda kufanya jambo hivi wanashtuka, ule mrembo yuko area anaweza tuchapa, ama anaweza fanya tu jambo story katokea. Ni kitu ya powerful sana, au sio? Wamama mademu mko ndani ya nyumba, tujipige makofi. Sawa kabisa, mambo murwa, mambo safi. Secondly, Bill of Rights. Mimi kama common mwananchi, mimi kama hoka, mimi kama jambazi, mimi kama broker, Bill of Rights dinanishikilia. Na mpaka sasa ukiuliza director wangu pale, kutekelezwa haitekelezwi. Bill of Rights vitu mob, implementation ni problem, haifanyiki. Na hiyo ndio chapter kubwa sana. Na tumekuwa hapa hizo masaa zote haituizungumzii wala tutaki kuzitaja. Alafu kitu kinanishangaza ati tuko na wanafunzi wa sheria waoga mno. Hakuna changamfu. Hata wale wako hapa na UN hapa, hatuoni wanafunzi wale wanajitokelezea, wale wako ready kutimiza ama kutekeleza chapter 4. Na tunaongea kuhusu mambo ya land. Chapter 5, land rights. Ukikuja shikanisha na Bill of Rights chapter 4, chapter 5 na chapter 4, mbona Kenya haiwezi kuwa smart? Kwa sababu sisi wenyewe ni waoga, na pia tutaki kujitokelezea na tutaki kujizungumzia. Tunataka wakongwe ndio bado wakuje kwa kiwanja wachangamshe hizi vitu, na wakongwe wakikuja bado tunasema wazee mmechapa, kaeni kando tuchukue shukani. Mnachukuaje shukani na tuwaoni? Maze hii Bill of Rights lazima angalia article 47 inatuelezea nini? Unanipata? Nikishikwa haki yangu ni gani? Nini 49 inatekelezwa? Article 49 mpaka saizi bado itekelezwe. Si ni kweli chali yangu? Lakini tunaizungumzia nini? Tunaisema kweli? Mimi nasema kwa ubaya ama kwa unyenyekevu. Wakati tunadiscuss mambo ya katiba 2010 na leo ndio sherehe. Mazee ICJ kuru nimeona hapo watu wa power feeder. Hiki tunafaiwe ni kitu moja powerful sana. Inafaa tunaongea kitu ya power sana, kwa sababu tukumbuke waliofariki ama waliokufa ama wale walidedi kwa sababu ya katiba tukitafuta. Wengi, ndugu yangu anaijua, wengi wamekufa kwa sababu ya hii katiba. Lakini sasa leo ndio siku yake, birthday yake. Sioni keki oriji hapa tukikula mzee. This vipi? Kwa hivyo nasema shukran kwa siku ya leo, na tuzidi kuipigania. Kitu muhimu tuipiganie kuitekeleza Bill of Right. Hiyo ndio muhimu. Asanteni sana.
Piganiwe, itekelezwe, si ndio? Inapiganiwa na nani? Inatekelezwa na nani? Sisi. So as we point fingers to the government, kumbuke there are others that are pointed towards us. Yesterday at the session at Kabarak, we had a CBO come and ask a question about how will they achieve these rights. I don't know, talking about formation of a labor trade union, and he was asking, you know, the employers are stopping us from forming a trade union. I asked him, who do you want to form the trade union for you? Kama uko na right, lazima uende ujipiganie, si ndio? You have to be the first one to fight for it, so that others can then come and join you. So I think that's a very good exhortation to all of us, that we can't just complain. We must take the step, as Gloria, as Faith, as Evans have done, to lead in pushing the government to implementation and to checking them whenever we can. Thank you so much. We want to now move to the very last bit of this proceedings, where we will do a book launch. And we have 2 books to launch today. We have a fantastic book called Many Tongues, One Nation. It is the preamble to of the Constitution of Kenya in select national languages. And I'm not sure how many languages they are. I'm not sure whether we are changing it to French and German and Portuguese, or what languages we are doing it in. So Chepkorir Sambu, I want to welcome her, and I just want to give a brief introduction of who Chepkorir is. Chepkorir is an adjunct tutor. She's a tutorial fellow at the Kabarak University.